So we actually just wanted you to briefly talk to us about your involvement with the marriage equality fight in New York State and at the federal level. Just introduce us to it.
Just in terms of, as Michael said, I've been involved with LGBT rights work for a number of years, and so we already had a relationship with Lambda Legal Defense. Through our work, we did a brief in the Boy Scout case, the Dale case, and Lawrence v. Texas. But at a certain point, I guess it was around 2003, they came to us and said, would you like to be our New York State marriage firm? Which at the time didn't seem like that sexy a thing because it was not thought that there would be affirmative litigation in New York. What we really researched first was the issue of if you get married somewhere else, will it be respected in New York? So at that point, they were anticipating Massachusetts, and they had Canada, and so we did a whole roadmap of that for that litigation, and that's actually what we spent the most of our time on, and actually we won those cases, and because of that, Edie Windsor was considered a legally married spouse in New York. So that's one of our contributions to Windsor. But what happened around 2004 is that all of a sudden the marriage issue exploded, and because of Massachusetts, but there were mayors marrying people as sort of protests on City Hall steps, and this was going on in San Francisco, but it was also going on in some towns in New York. And so very quickly, we realized the major organizations had to start bringing affirmative cases in New York, or people who weren't as qualified were going to start filing cases, and there's no telling what would happen. So with about 3 days' notice, my firm was asked to jump in. It was the most exciting thing I ever did as a lawyer, because it's one thing to write those briefs sort of supporting the parties, but to actually be the party was just thrilling. And so we put together a case. We filed a complaint really fast. We put together a big summary judgment motion, and we found clients that represented a cross-section of couples to try to get away from the stereotypes of who cares about marriage. So it was different ages, different ethnic backgrounds, with kids, without kids, and we had 5 families. And everyone sort of knows that what happened. We ultimately lost the case, but we won at the trial level, which was unbelievably thrilling. It went up on appeal, and we lost the intermediate appeal. And then in 2006, we went to the Court of Appeals, and there were actually 2 cases. There was ours, which was called Hernandez, and there was another one called Samuels, which was litigated by Robbie Kaplan, who's now very famous for having been Edie Windsor's lawyer with the ACLU, and we were with Lambda. So I think we had good teams, and we presented an affirmative case. And a lot of the issues that are now you hear about being argued about marriage equality and what the reasons could be for excluding gay people from equality are very much the same issues we litigated 10 years ago. So there's nothing surprising coming up. We did lose. It was the only case I ever worked on that made me cry twice. First one we won, and then at the end. But the decision was so stupid that there was a backlash to some extent. And within 1 year, we had a marriage equality bill that passed the Assembly in New York State. We have one of the most dysfunctional state legislatures in the country. So the fact that it only took 4 more years to get it through the Senate is actually pretty good. So we did legislatively enact marriage equality in 2011. And we weren't the first state, obviously, and we were trailing even New Jersey, which was embarrassing. But no disrespect if anyone's from New Jersey. But so I guess we were maybe the 4th or 5th, I lose track. But then after that, it's really accelerated. And we now have 17 states and the District of Columbia. What's accelerating it even faster now is these 2 cases that were decided last summer. Perry, which left standing a decision that struck down Prop 8 in California. So that basically had marriage equality going forward in California, which is huge. And then Windsor, which struck down a part of the Defense of Marriage Act, that basically the part that says even if a state affirmatively allows same-sex couples to get married and wants to respect those marriages, the federal government won't. And that was struck down. It's going to be a year in June. And the big question is that limited to just a federal versus state issue, or does that have a broader principle? But what's happening now is many cases are going forward in different states, challenging the state bans in the states that still won't allow same-sex couples to get married. And they're reading the Windsor decision pretty broadly. And so it had a series, it's unbelievable, about 10, 12 decisions in the last 6 months in places like Utah and Oklahoma, places you would not expect culturally or politically for this to happen. from federal judges, but some of them are not necessarily liberal judges. Some of them are Bush appointees saying, given the principles, and we'll go back and talk about how it links up to the earlier civil rights movement, but given what Windsor says, you got to let people get married. And so that's now heading, I guess we'll get to it more, but it's heading for the Supreme Court again. So that was our big involvement. And in the Windsor case itself, we did a brief, what we call an amicus brief, friend of the court brief, in both Windsor and Perry, and we represented a range of mainstream religious organizations. And the point of that brief was to say there's no single Christian definition of marriage. First of all, you're not supposed to let religious definitions determine civil law, but don't think that you can pick one view and say that if you pick one view that way, you're not just discriminating against non-religion, you're discriminating against an increasing cross-section of mainstream religions that embrace same-sex couples and are in favor, which includes the Episcopal Church, includes Reform and Conservative Judaism, it includes Quakers, a lot of other groups, UCC. So that was one of many briefs that were filed that showed this really mainstream acceptance. You had business leaders brief, you had Republicans brief, and all of that really helped sort of create the momentum. So we're doing those briefs again now in all these cases that are coming up. So that's, in terms of the marriage, my only involvement in marriage, those are really the high points.
Mm-hmm. Thanks.
Well, I think you said so many things that I think for this audience, it was great. It would probably be great to give a little bit of context. In 2004 was 10 years ago, and if you're a college-age person, that means you were 10 or 11. But 2004 was a period of time where, because of the tight election between George W. Bush running for his second term and Senator John Kerry from Massachusetts, in a number of states, political operatives decided that a way to galvanize the right-wing base to come out and vote for George Bush was to put constitutional amendments banning gay marriage on the ballot. And so all over the country, in a number of states, Jeff, do you know how many states?
I don't know exactly how many. I know about 38 to 40 states either have mini-domas, which are statutes that do that, or they have constitutional amendments.
And every one of these constitutional amendments passed, often with fairly substantial majorities, which suggests that there has been a phenomenal sea change in just 10 years between the views expressed in a number of these states when they approved these constitutional amendments and the views that are showing up in state legislatures and in national polls. And it's in this context that Jeff and his firm were involved, along with many, many others, in fighting it on the legal front, but also the very nature of these legal fights helped change the conversation. And I thought that would be a useful background to you.
Yeah, it's part of a broader cultural shift. I mean, the visibility of gay people in America has completely changed. The generation that grew up watching Will and Grace is very different than the generation before that. And increasingly, it's kind of a non-issue, even for conservatives. So you're seeing that shift. It's very much tied to demographics and age. And every year, about 1% increase in acceptance in terms of the polls. And we now have a very clear majority nationally for marriage equality. The interesting thing we saw in Utah when we were doing our brief for the Utah case, 70% of Mormons are in favor of relationship recognition, at least civil unions, and about 30 or 35% are for full marriage equality, which is pretty amazing given that conservative community. But anyway, so
why did you personally get involved?
I mean, it's the civil rights issue of our generation. Not to say that the other work is done, but it's one that was exploding very quickly in this generation, and my firm actually has a history with it a little bit. I mean, if anybody's familiar with the play The Normal Heart by Larry Kramer, which will be an HBO movie next month, in May it's going to be on, maybe more of you will know it, but it's a play about the early days of the AIDS crisis, and Larry Kramer's a playwright and activist, and it's all in the play, but he got his brother, who is the founding partner of my firm, he actually went behind his brother's back to do this, to get our firm to do the legal work to set up Gay Men's Health Crisis, GMHC. So we've been doing legal work for GMHC for 30 years, and even before I was at the firm, we had a connection to these issues. The way I personally got involved is a friend of mine was at another firm, and they were representing James Dale, who was the Boy Scout, the Eagle Scout, who got thrown out of being a junior scout leader when he came out at Rutgers and identified as gay. And that was, we did the brief we did in that case, what we used to call Gay 101, it was basically like, gay people are normal, they're not going to molest your children, it's not a disease, it's like the kind of stuff you don't even have to say in the papers now. But it was fascinating to see. That case really did start a big amount of change. When the case started, people were saying, like, why doesn't that kid leave the Boy Scouts alone? You know, and by the end of the case, they were saying, what do the Boy Scouts have? What's their problem with him? Even though some people did support the Boy Scouts' rights to say we're a private organization, we can have our values, they ended up winning on the First Amendment ground. Even people who agreed with that were like, well, what's your problem? And why is that really part of your values? But that was sort of the beginning of the big change, I think, on this issue, which continued. So that's sort of how I got involved, and then, you know, various other things we were asked to do. I actually had a summer associate who was really interested in this, and he went to clerk, and when he came back, I got him a little 3-month placement at Lambda Legal to replace a lawyer who was on maternity leave, actually, and he got involved in Lawrence v. Texas at the trial level. And when he came back to the firm, that kind of cemented the relationship. So we just got offered great work, and we continued to do it, and it was fantastic. So it's been very rewarding.
Should he explain Lawrence v. Texas now?
Yeah, why don't you say a tiny bit about what Lawrence v. Texas was? We've done it, at least for our class, but there are some visitors here.
Okay, well, Lawrence is, in terms of the law of relationship recognition, before you could get to marriage, you had to decriminalize the conduct. And as long as sodomy laws still made it possible for gay people to be criminally prosecuted for having sex, it's a little hard to even conceptualize the relationships being respected legally. So Lawrence follows from a case called Bowers v. Hardwick, which is about as popular in the gay world as Plessy v. Ferguson, which in 1986 said that it was okay to break into someone's house and arrest them for having sex. And what's really interesting is it depends in some way on how you define the right that's at stake. And the way in Bowers they said, well, there's no deep-seated, fundamental, long-recognized right to engage in sodomy. Okay, if you look at it that way, maybe there isn't. And Justice Blackmun had a wonderful, very historic dissent in that case in 1986, where he said, no, this is not about the right to a sex act. This is about privacy and dignity, and the right to be left alone, and the right to have your relationships and personal private choices respected. And Lawrence comes up in 2003, and that's pretty quick, actually, for a major Supreme Court case to be overturned. And in Lawrence, again, it was a challenge to the sodomy laws, and the world had just changed so much. I was actually in the courtroom for the argument, and what you had, actually comparing it to the Boy Scout case, which was in, I guess, 98, where Evan Wolfson got up to argue, and it was really an uphill battle, and there was a lot of hostility and tension in the room. 2003, this guy named Paul Smith argued Lawrence, who was an openly gay former Supreme Court clerk, partner in a big firm, regular Supreme Court advocate, very comfortable there, and the justices knew him, and that really changed the tone. And as I'll talk about a little bit more, there's sort of two strains of law that are involved in these kind of cases. There's equal protection, and there's what we call, sort of stupidly named, substantive due process. It sounds like an oxymoron, but basically it has to do with the recognition of fundamental rights. So one is about not discriminating against groups, and one is about not taking away fundamental rights. And so the issue again was, well, what's the right? And everybody assumed that they would strike down Lawrence on some kind of equal protection theory, that, you know, you're not prosecuting straight people for having sex, so you can't prosecute the gay people. But Paul argued, and the last few minutes of his argument were so moving, and he said, the issue here, the fundamental deep-seated right, is the right to be left alone in your home and have your personal dignity respected. And he said there are people that don't necessarily agree with the gay rights agenda, but they're shocked to learn that the police can come and bang down your door and come in and arrest you for private, adult, consensual conduct. That's a deep-seated American value. And you could see that they'd stopped asking questions, and you could see he mesmerized the room, and we all walked out saying, you know what, this could be a due process decision, not just an equal protection decision. And in the end, it was. Now, Justice Kennedy did not come right out and say this is a fundamental right, but the feeling of the case was a fundamental rights case. He ultimately said there's no rational reason for this, so there was no need to. I don't want to get into constitutional technicalities, but if you have a fundamental right the law has to satisfy a very high level of scrutiny. It has to be really a compelling reason for the law. But if the law is irrational, then it gets struck down with an easier, you don't need to have the fundamental right necessarily. But it was a real change in attitude, and they said that Bowers v. Hardwick was wrong when it was decided, which they don't often come out and say that a few years after a decision. But they said it conceptualized the issue incorrectly. The issue is personal dignity and privacy and autonomy. And now, the interesting thing there is you have Justice Scalia writing a dissent saying, oh my God, you've just now eliminated any legal rationale for keeping people from getting married. And he was horrified. He was saying this in horror. But we all looked at each other and said, yeah, that's right. And it's no coincidence that once you got rid of the criminalization and the stigma, the logical question of what's next, the relationship should be respected the same as they are for non-gay people. So it's only a year later that we had marriage in Massachusetts and that whole thing started. So that was really a turning point.
Just to follow up on that, who else was on both courts in 86 and in 03 besides Scalia?
That's like a trivia quiz.
Actually, maybe he's the only one. Is that possible?
No. There must have been others who. 86, Kennedy wasn't on yet.
No.
And Kennedy is really the pivotal figure in this. He wrote the other major earlier, just to cover the waterfront on the big gay rights cases. There's a case called Romer v. Colorado in 1996, which was about Colorado passed a law that basically said no local government within Colorado can pass a gay rights ordinance, even if you can politically get your town or city to enact a gay rights ordinance or some protection. You can't do it. And the Supreme Court struck that down basically on, again, with sort of no rational reason. It's only motivated by hostility for a group, the desire to disadvantage a group and attack the dignity of a group. And on that ground alone, knocked it out. And that was really a pure, I think, equal protection kind of analysis. And that was written by Kennedy. When Kennedy first went on the court, a lot of us thought, oh, he's horribly conservative. And on some issues, he is. He voted for the horrible Voting Rights Act decision last year. But on this issue, he's really seen the future more and been much more enlightened. And so Justice Kennedy was the swing vote Romer was 6-3, I think, and Lawrence was 6-3. And then he wrote the Windsor decision, which is more recent. And now everybody's waiting to see if he'll be the fifth vote to, well, I guess we'll talk more about that, but I don't know if I'm jumping around a little bit.
Yeah,
so I don't
that's
know.
Okay.
I don't know if you want me to back up now and try to tie this into Brown and
Yeah,
about to
that
ask
was
that
just.
Is that where you were going next?
Say.
Okay,
Yep,
because
that
this
was
is a
on my
class about
paper.
Brown versus Board of Education. Okay, well, the question was how does this relate to Brown? And my initial thought was, well, maybe not so directly, but I went back and I read Brown, which I hadn't done in a long time. It's a very short decision. It's short and a little general and a little vague, and part of the reason is that Earl Warren wanted it to be 9-0. It was very, very important because of what he was up against in the country to have a united court stand for that. So it maybe doesn't go quite as far as one would like reading it now, but reading it then, it must have just been amazing. And I also read Loving v. Virginia, which is what struck down the anti-miscegenation laws in 1967. And there is, there are obviously tremendous differences between the problems being addressed and the histories involved, but there are definitely commonalities. And Brown is essentially equal protection issue. It doesn't really focus on like a fundamental right to education. It focuses on the discrimination between groups. And the stuff I've been mentioning about dignity and disrespect and that kind of thing, it comes out of Brown. It really talks about why is separate but equal no good? You could make facilities equal. There are separate but equal facilities. We have separately gendered bathrooms. We don't think that that's a horrible violation, although there are issues for trans people, but we don't think it's demeaning to have a women's room and a men's room. But the reason separate schools are unconstitutional is that it's demeaning. It's disapproving of a group. And that's really the core of the values in Brown. And that becomes a dominant value. And the article you handed out, the article talks about how that informed the debate over the Civil Rights Acts in the 60s, that there was the indignity of segregation and of Jim Crow, which was just, that was the purpose of it, was to humiliate and oppress. And so that comes, you can see that coming down in Romer, where they said no reason except to disrespect and disadvantage one group. You can see it in Lawrence, where they talk about the dignity. I mean, there's language in those decisions that almost, it talks about the state cannot demean, petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. It's that sense of demeaning that goes back really to Brown. So now the due process part, the fundamental rights part, you see more, I think, in Loving v. Virginia. Now, Loving v. Virginia really has both issues, and the longer discussion is actually about equal protection, which is basically what they were mainly doing was answering the argument. Again, it was sort of separate but equal, like because those laws applied equally to whites and blacks, it wasn't unconstitutional. But they said the purpose of the law was to preserve white supremacy. It was to keep the white race pure, and one way they could tell that is other races were not prevented from intermarrying, only whites and another race. So that was sort of a tip-off, if it wasn't already obvious. But there's also a discussion towards the end, which we focus on a lot in the marriage litigation, which talks about the fundamental right to marry and the fundamental right to choose who you marry. And that is a separate basis to protect the freedom to marry. And that obviously has a much more direct lineage to the same-sex marriage debate.
Jeff, just quickly, what's the constitutional root of that fundamental right to marry?
The constitutional root, R-O-O-T?
Yeah.
Well, I don't know. There were some earlier decisions. There's this whole line of cases that actually backs up Roe v. Wade as well, Griswold, which talks about, there's a similarity there too about the right to be left alone, the right to make intensely personal private decisions. And there's a lineage of that to Lawrence as well.
Do you think it comes from the Fourth Amendment, the right to be secure in one's own person, in one's own home, which is in effect a right to privacy? Or?
Well, one of the critiques of this whole substantive due process thing is that it doesn't really clearly come from anywhere, and that it's sort of, in fact, in Griswold they talk about the penumbra of constitutional rights, that are like, it's a star with, and that's always been criticized by the right-wing scholars, like you really need to do something more than find a penumbra. But there are different values in the Constitution that come down, and obviously the Fourth Amendment has some of those values, the right to be left alone in your home. Obviously, in racial cases, the 14th Amendment is quite literally on point because it was intended to eliminate discrimination. Of course, at the time that they passed it, as we were discussing, they had segregated schools in Washington, D.C. under the approval of that same Congress. So if you're really looking at original intent, there still has to be some sense of a constitution as a living, breathing document. It's not a statute that you literally read the words. It's a statement of broad principles and values. And the mainstream of American jurisprudence has always viewed that as within certain guidelines and interpretive rules, and you don't just change it all every day, but that changes in society can be reflected in the changing understanding of what those rights are. And actually there's great language in Lawrence about this. It's the kind of thing that drives Scalia insane. But where Kennedy says, where is that? He says, had those who drew and ratified the due process clauses of the Fifth or the 14th Amendment known the components of liberty and its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew that times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. Beautiful language. So that, that's the mainstream understanding. It's people like Scalia who say, no, if it doesn't say it right there, and if they weren't thinking of this in 1789, then it can't be part of the law. That's really not how we view the Constitution. So,
Well, we have a, want to do this?
which kind of stuff do you want to do next?
State, did we finish the federal stuff?
You want to do
Any other federal connections?
Federal connections. See,
I had Brown to marriage equality.
well, I mean, those are the major cases in terms of the way the law evolved, and I sort of already discussed Bowers and Romer. Windsor itself is legally a complete mishmash. It's a very strange decision. This is the one that was decided last June. Kennedy, I think, is being intentionally a little vague to keep his options open, but you have a rhetoric and language that make it sound like an equal protection case or sound like a due process case, and it can certainly sound somewhat like a federalism case. And, the funny thing with Windsor, of course, is, again, you have Scalia saying, oh my God, you say you're just limiting this to striking down DOMA, but you've just put the blueprint in place to strike down all the state laws. And he actually took a paragraph from the decision, and he said, look how you can just substitute words. And he plugs it in like a Mad Libs, and he said, the same analysis, and of course he thinks he's saying something in horror. Everybody else is saying, yeah, that sounds good.
In the next case.
Yeah. And then Chief Justice Roberts reads this, and he says, well, wait, I don't want to necessarily make this a foregone conclusion. So he writes a dissent in which he says, no, I read this as really turning on federalism. Federalism meaning the adjustment of rights and powers between the state and federal government. And one of the big things that led to striking down DOMA was that it was traditionally the states that define marriage and regulate marriage. And it was very unusual for the federal government to come in and say, oh, no, we're not going to recognize these marriages. And to do it in a sort of sweeping way that without making judgments about how it plays out, there are thousands of regulations that were affected by that. And it was clear when you read the record when they passed the Defense of Marriage Act, this is in 96, it's clear that they were just panicking about the possibility. This is actually when the first case was going on in Hawaii, which is really where it started in 96. And they were afraid there was going to be marriage in Hawaii. So they passed this. The other part of DOMA says that other states don't have to recognize the states where the marriages are performed. And that's sort of neither here nor there because states have their own bodies of law to determine when they're going to. Nobody's making them recognize those marriages until the point when it's unconstitutional, and that part is going to come up now. So you could look at it as well. They overstepped and they took away from the states something that's normally for the states to decide. And Roberts wants to make it sound like that's all they decided. But the values, and they talk about, again, demeaning these families, showing no respect for the families. They talk especially about the impact on kids, how humiliating it is for kids to be told, no, your parents can't get married. Your parents' second-class relationship. There's a wonderful, wonderful part of the argument where Justice Ginsburg says what's become sort of a famous line. She says, you're basically saying there's this sort of regular marriage for some people, and then there's this kind of skim milk marriage for gay people. And got a big laugh in the courtroom, and it became a whole meme on Facebook, but that really encapsulated it. So again, you have that theme of personal dignity and demeaning people and making them the other that I think runs through all of civil rights law. So the question now is really how will the other courts read it? And most courts so far have not read it as a federalism decision. They've read it as an equality decision. And they say there's really no good reason that can justify the continued ban. And we've actually had trials in some courts where they say to the marriage opponents, so prove it. Prove there's some reason to exclude people. Prove that somehow kids are harmed by having gay parents. Prove that, somehow allowing gay people to get married is going to harm the marriages of straight people or cause straight people to not get married. It's all absurd. And nobody can prove this because it's ridiculous. So it's really snowballing, and we're now expecting a bunch of rulings in the courts of appeals. And it's going to be awfully hard for the Supreme Court not to take one of those cases. And then what you're going to have, and I think this is also one of your questions, so I might as well do it now, are we ready for this? Are we ready for the Supreme Court to say, okay, everyone has to do marriage now? And, probably privately, a lot of people who are in this movement would rather have 25 or 30 or 35 states already lined up, and a lot of those done by legislation, not just by courts. But I feel a lot better about it than I did a year or two ago. We now have a growing plurality. We have, 17, and you're going to have these rulings which will apply to several more states. So you may really be over 20 to 25. But the Supreme Court has this role that's both legal and cultural and political. And the Supreme Court, when something's sort of going a certain direction culturally, politically, there's a point when the Supreme Court kind of pushes it over the finish line. And then there's always a debate about whether it's too soon or too late or what. Brown led to a big backlash. It led to all kinds of problems of enforcement, which ultimately we can say it failed because we still have economic segregation and racial housing segregation. So now we don't have schools segregated by law. We have schools segregated by where people live and who has money and that kind of thing. I think we did San Antonio versus Rodriguez. That was the loss that's led to us now having more segregated schools than we used to. But what was I saying?
Well, Brown created a backlash.
The backlash. Yes, I'm sorry. But nobody really seriously argues that Brown was too soon. Even though the implementation was so hard, it was a point when that had to be done, and that had to be the impetus, even though it was so hard, so much fighting after that. There's contrasting discussion about Roe v. Wade. And in fact, even I think Justice Ginsburg has been quoted as saying perhaps Roe v. Wade came at the wrong time because you had this trend of liberalization in the state legislatures on abortion regulation. And this decision, which enforced abortion rights on the whole country, led to a massive backlash. And there's a little bit of a concern, are we maybe in the same point here, and you're going to have this horrible backlash if it's imposed on the whole country. I'm not worried about that. I think it's very, very different than abortion. I'm pro-choice, but I can see that there's a legitimate, debatable other side to that issue. There are people that feel passionately about it and will always feel passionately about that issue. Marriage equality is kind of a stupid non-issue at this point. Yes, there are people that still they're still resisting it, but it's fewer and fewer people who feel so strongly about it that they're going to get really upset. And I don't think enough of a backlash to have the effect of people being run out of office or judges being impeached. I think those days are gone. And I think, yes, there'll be some backlash. The right will try to seize on it as, activist judges imposing their will on the people. It's not going to fly because we have a majority in this country supporting same-sex marriage. In 1967, a much lower percentage of the country approved of interracial marriage. Now, it's true you had far fewer states imposing those bans, but culturally, politically, we weren't as far along as we are now with same-sex marriage. And they did Loving v. Virginia because it was the right thing to do. And, I don't know how much, I'm not really sure of what the backlash was at the time, but I don't think it was so bad. And, part of it is that 1967 was sort of a tipping point politically, to the point where when the movie Guess Who's Coming to Dinner came out, it seemed too mild. When it was finally released, when it seemed so radical when they proposed it in 1966. But so I think this is very different. I think this will be more like Loving and less like Roe, because I think ultimately there is no real argument on the other side. It just kind of collapses. And so I don't think it's too soon. I would have been concerned 2 or 3 years ago. Now I'm not.
Oh, great. You answered our last question.
Oh, my God.
We're going to ask our next to last question.
Okay.
And then we'll open it up.
I'm skipping around.
No, it's fine. We weren't sure what order anyway to ask these, so.
However my synapses fired, you're going to get them.
Yeah,
okay.
They're great. So now to the state level, just briefly, could you talk about, we know you've made some real progresses with New York state law, and do you see New York as a trendsetter or more of an outlier? I guess at this point we know you see it not as an outlier, but anyway.
No,
talk about.
I wish we had been much more of a trendsetter because it was embarrassing, as I said, to have New Jersey. They got the civil unions first, but we leapfrogged over them, and then they eventually got marriage too. But they got a good marriage ruling. They got the ruling that said, look, this is unconstitutional, but because it's unequal. But you could have civil unions with all the same rights, and they tried that for a couple of years. And the civil union thing is just ridiculous because it just creates complications, and it doesn't, And really, if it's not demeaning, then why are you bothering to do it? That's the reason to give it a different name, because it's demeaning, because it is not entitled to the same respect. So that has had a very short shelf life, and they went back and did marriage properly. But we were still ahead of most of the states. I think having New York do it was a big thing. It fueled. I mean, if you think of the gay population, then adding California, you're getting a big chunk of the gay population there. and just very big populous states that are the center of media attention and that kind of thing. So, but the problem is, at a certain point, you ran out of states that were up in the air. You had a few states that didn't have marriage, but also didn't have a mini-DOMA or a constitutional, like Rhode Island. And so for a while, we were still litigating this question of recognizing out-of-state marriages. But most of those states have now approved it legislatively. So now we're down to states that either have constitutional amendments, which are very hard to overturn politically. It takes a long time. You have to sometimes vote in two different legislatures and have a very high percentage vote. The mini-DOMAs can be reversed by a majority of the legislature. So some of those have just been overturned, I think Minnesota and some other states. But the state-by-state thing will continue. But there's going to be, places in the South and places in the West where politically it's going to come more slowly. And I think it's going to be ordered by the Supreme Court before get to that point. It was funny, though. I know a guy who wrote a play about this, and it's called The Night Larry Kramer Kissed Me, actually, which was actually a bunch of monologues about the early days of the AIDS crisis. But David Drake, he did a benefit performance of that play recently, and he wrote a little coda, which was a funny little sketch about looking back in 2020 about how marriage finally came around, and wasn't it great how this happened and that happened. And then, of course, Utah, that was the last state, Utah. And after the Utah decision, I emailed him and I Facebooked him. I said, you got to rewrite that play. And he was cracking up because, who would have thought Utah would only be like the 18th or 19th state? But that's the power of the independent judiciary.
And now it's time for you to ask questions. We have a microphone here. Questions? There we go. No,
It's not on.
oh, Dan, we need. No, he needs to turn the mic on because we need it for the morning.
Yeah.
There you go.
Okay.
I remember the last speaker. She spoke about some global issues that help, I guess, put pressure on the United States Supreme Court to, pass or to even pay attention to a lot of the civil rights. So I was just wondering, are there any global issues that are, I guess, being confronted right now that may, promote LGBTQ rights to be passed quicker? Like, maybe something that we see in the global community that we may want to, look differently.
Well, I'm not sure what you're getting at, but because that could refer to a lot of different things. Certainly.
After World War II, the whole Holocaust was based on color. So when they confronted with a lot of the civil rights for black people, we wanted to have a different approach. We couldn't look at it the same way as the Germans looked at color, based on that. So I was wondering, was it any issues, with gay people maybe in other countries where they're being persecuted and we're trying to take a different approach?
I think that the Supreme Court responds to cultural trends and political trends and things that happen. One interesting thing is that in some of these decisions, Justice Kennedy is actually very big on looking at international law. And he's often, in terms of Lawrence, he talks about how countries are moving away from this kind of persecution. And I think in Windsor there was some discussion about changing norms. So there are other justices that say, no, America first. Who cares what those crazy foreigners do? And there's actually a debate within the Supreme Court about how much to look at other countries and how much to look at sort of real world stuff and social science and that kind of thing. So, but the changes in society end up affecting the court. The court is not immune to it, and they see changing acceptance. You want to talk about, you mentioned another thing which is very troubling, which is a lot of countries in which persecution of gay people is really on the rise. And, in Uganda and Nigeria and Russia, and that's very unfortunate. I'm hoping it will sort of strengthen our resolve to stand up for our values, but it just shows that the world is a very varied place, and on this issue, in some ways, I mean, from talking to friends from other countries, the issues are conceptualized very differently. And in fact, there's a person I've been working with who's starting an organization that's going to do LGBT rights litigation sort of on the ground in the domestic courts all through Africa. But depending on where she is, she can't call it gay rights. She has to call it women's rights, or she has to call it sexual privacy, because of what's going to fly culturally, locally, and also just what concepts are understood locally. Gay as a construct doesn't exist in the same way in every country. Is my understanding. I'm not an expert on that, but in some countries it's accepted, but it's not called what it is, and it's not. So how it translates into political and legal rights is not always predictable. I'm not sure if that answers what you're saying, but certainly the Supreme Court is aware of changes, and some of them are more likely than others to sort of acknowledge that and factor it into their actual decisions. Kennedy is a big advocate of that, of looking to comparative law and foreign law.
You made a statement earlier where you said that they are scared of gay marriage. By they, I assume you mean the government, and I just want to clarify, what do you think exactly they're scared of? What frightens them about it?
Well, I was talking about Scalia, I guess, more than anybody else, because I sort of see him as sort of the key villain, because he keeps bringing it on himself by making public speeches and so on. Look, I think that people who are older don't have the life experience. I think that familiarity tends to reduce fear, and that's why I think younger people who have had gay role models and gay characters on television, that kind of thing, whether you think you know someone gay in your life is very closely relates to your attitudes. Justice Powell, who was the swing vote in Bowers v. Hardwick, the bad vote, had a gay law clerk at the time but didn't know it, and claimed he had never met a gay person, which is impossible. But now you have openly gay law clerks. Probably every justice has had one or two, and so the same way everyone's now more aware of their cousins and uncles and friends and people in their life, it just becomes normal. And so I think that kind of fear. Scalia is older. He's very religious Catholic, which is something he was raised very much condemning that. But look, even within the Catholic Church, look at the new Pope. He sort of can wake up and smell the coffee. I mean, he's trying to move without changing doctrine so fast. Let's not expect him to radically change anything. But he's changing the tone of the discussion, and he realizes that he doesn't want to be left behind in a world that's becoming more accepting. So you see it changing everywhere. So I think it's very age determined. And another example, I have an aunt who was 2 years ago was about 80 years old, and I was talking to her about this, and she said, well, I'm for equal rights and everything, but marriage, I don't know, marriage, it's like so tied up in religion and this and that. I said, what are you talking about? You were like a communist. You took me to peace marches. I mean, how can you, but it's cultural. If you're 80 years old, you probably just never thought about this. And she's actually with the program a little better. Now she's 85 and she's cool about it. But it takes time. My father, who passed away last year, was also a very big supporter in his late 80s. So, times change.
More questions? Right there.
I guess I could ask, when you look at, race as a social construct, and how people say it's not basically based on only skin color, it's created by society. Do you think being gay, if you take away just the sexual preference, is it a set of characteristics that people expect you to act when you're gay? Like, I guess that's it.
I think there's a lot to it. I think it's somewhat more fluid because people can choose to change how they identify. Who you basically are is probably determined biologically or psychologically at a very early age, and so the idea that you can, people try to make contrasts, and they say, well, it's just a lifestyle choice. But that's not fair. There's a fundamental orientation that most people have, but it can change over time. And these categories are all social constructs to a point, I think. And the easiest way to address it is just to say everybody should be treated the same. Everybody should have the same rights, and it shouldn't matter. that, you're 1/8 black, so you're black, or whatever. They actually use, the statutes used to say that, and it's that's totally a social construct. But we're all from different backgrounds. Eisenhower had black relatives in his past. There was a Life magazine article they were going to run about that, and it was suppressed. Because nobody wanted to think, oh my God, we had a black president. That would be horrible. But Eisenhower was probably the first black president. By the definition of some states, maybe he was 1/16 or whatever. But the point is, you should have the right to identify and be whoever you want to be, and you shouldn't lose your fundamental rights because of it. It raises an issue which I did want to address briefly, which is that there is a lot of over the years there's been tension and debate between sort of the old school civil rights movement and gay rights, and a number of older people in that community who say, you're moving too fast. We took a lot longer to get there, and you're disrespecting us by saying you're exactly like us. And those are very legitimate issues. The experiences of African Americans in this country is like nothing else in our history. It defines our history in many ways. And I don't know any gay activists who would want to say we're exactly like them. Or that it's not a fruitful debate on that level. As I remember being an undergraduate at 3 a.m. on the 4th beer and screaming at each other, what's worse, the Holocaust or slavery? Not a productive discussion. What we should really say is there's no quota on freedom, there's no quota on happiness. There's enough marriage for everyone, there's enough equality for everyone. And looking at it as a lawyer, to say that somehow the great civil rights decisions are limited to their facts, only apply to the situations where they came up, is actually to diminish them. And the point of it is these cases, Brown and Loving and the other major civil rights decisions, they state great principles and great truths. And the point is that if they apply to other situations, that makes them more important in a way. And everybody who takes advantage of it doesn't have to identify as identical, but there's actually a line at the end of that other passage that I read in Lawrence, which talks about how times can blind and so on. The last line of that paragraph, I saved it for this moment. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. That's the most important line to me in Lawrence, because it answers that question. Civil rights is for everyone. Nobody has to justify that their suffering is as bad or worse than anybody else's. And now, that said, there's a lot more cooperation and respect that ought to happen between different groups, different organizations, and there's a legitimate critique of the gay rights movement that it has not been as concerned about people of color and how they're affected, and the double and triple whammy of being homeless gay youth of color on the street, and there's a debate about whether there's been too much emphasis on marriage. I don't happen to think that's bad. I think eliminating structural discrimination is necessary but not sufficient. And the question is now, will the wealthier white male gay people who write the big checks to the lobbies and the groups still write the checks when the issue is the rights of transgender queer kids on the street? And by the way, 95% of which are people of color. I have a friend who runs a small nonprofit that does legal work for that population. Very vulnerable population. So again, we shouldn't be pitting people against people, but we also should remember the most vulnerable people in the community still need help, and people have to have the imagination to still care about it when it's not directly affecting them. And we'll see if gay organization world can continue to move in that direction. Certainly there's been a tremendous, by the way, today is Transgender Awareness Day. I don't know how many were aware of that, but the transgender community has only in the last few years started to move slowly into the mainstream and get more mainstream acceptance. The legal issues are tough sometimes. Even things that we take for granted, like the gendered bathrooms, become questioned. And but that's kind of where the action is to me, because that's the population that's the most vulnerable and whose rights need to be protected. And they need identity documents, they need medical care, and there's a kind of discrimination and harassment that's the last socially acceptable bigotry. So that's sort of the next struggle. By the way, the marriage should help them too. Marriage, if anybody can marry anybody, it doesn't matter what gender box someone wants to put you in. Any two people who love each other can get married. So I think marriage is going to have more impact on different people and on lower income people and on people of color. I think people tend to stereotype it and say it's only rich white guys who want to get married, but I think there's still more work to be done beyond it as well.
That actually brings, I'm going to take advantage of the microphone and ask a question. My sense is that the fight for marriage equality was one of these examples where the troops were way ahead of the leaders. That the leaders of the established gay rights organizations had not necessarily thought of that fighting for marriage equality was all that important, that they wanted, acceptance, they wanted an end to discrimination in jobs, they were concerned about the fact that AIDS was considered a gay men's disease and therefore wasn't getting the resources, etc. Is it true that the fight for marriage equality kind of bubbled up from people just demanding it and wanting it, and the leaders ended up having to follow?
No, I don't know if that's really, to some extent, I think, you had people thinking about it seriously. Evan Wolfson, who argued the Boy Scout case, wrote an undergraduate paper on it, and arguing a strategy for marriage equality, and by the way, he got a B. That paper is now under glass at Harvard. I remember it was in law school, maybe, not in undergraduate. They have it in a case to show, how even something that gets a B can change the world. But he did the Hawaii case in '96. And I think actually the critique sometimes comes from the other direction. It's like once you had a lot of focus on AIDS and a lot of urgency about AIDS, and then in the mid-'90s, when they came up with the sort of the cocktail of medications that kept people alive and made it not an automatic death sentence, the attention started to shift to other issues like marriage, and there's some concern that in the last 20 years or 18, 19 years, we've disregarded that, and now we have a rise in HIV infections. And there's a movie my colleague Peggy here was involved in making called How to Survive a Plague, which talked about ACT UP and the days of fighting for awareness and funding for AIDS research. And some of the people who survived that time are now kind of critical of how much time and money we spent on marriage. But I feel like we should be doing both. So I don't think it's an either-or question. What you did have, though, along the lines of what you said, is there was definitely a commitment to being very cautious about how it was litigated and doing it on a state-by-state basis. And the mainstream sort of ACLU, Lambda Legal, bigger organization, the conventional wisdom was stay out of federal court because we don't want to go to the Supreme Court and lose. And they were correct that we needed more social change and cultural change, and we needed to have some victories on the state level. And the big focus in Massachusetts on litigating it under the Massachusetts Constitution, and that's where we won Goodrich, and that was really the first big precedent. And we litigated Hernandez under the New York State Constitution. We wanted to stay out of federal court. At some point, that started to tip, and you started to see people bringing challenges to DOMA. And Edie Windsor, who is the feisty 84-year-old who won the case last year, she shopped her case around, and a lot of organizations did not want to take it. And she found Robbie Kaplan, who's a private commercial lawyer like me, at Paul Weiss, and Robbie had the vision to sort of buck the trend and say, by the time this case gets to the Supreme Court, the country will be ready for it. And she, to her credit, went to the ACLU and got them to sign on, because she's not really any more of an expert than I am. She had done her one big case, but you need the real experts involved. So the ACLU and Paul Weiss did the Windsor case, and you had a couple of other cases. But actually, the other thing is that the Perry challenge, the Prop 8 case, was brought by, you probably read about David Boies and Ted Olson, who were the two guys that argued against each other in Gore v. Bush in 2000 about the presidential election. Olson is a big Republican and Boies is a big Democrat, and they together brought the big challenge to Prop 8 in California. And by the way, they are getting paid. They are private attorneys. They're getting paid by some foundation that wants to put the money into this. So those of us who do it all pro bono are a little resentful when they get all the publicity. But they also were like ahead of the curve. They said, Gay Inc., as we call it, is too conservative. We need to push the envelope. And the fact is, when both of those cases got to the Supreme Court was ready. I mean, in Perry, it was a very complicated procedural posture. They could have taken Perry and said there's a constitutional right to marry and impose it on the whole country. Nobody expected them to do that. What they did is they left standing a decision that struck down Prop 8, so it only applied to California. which was a big step forward. And for those of us who've been doing this for a while, striking down DOMA and winning back California was enough for one day, let the country absorb that. And then we'll be back, in 2 or 3 years or 5 or 6 years. It's happening faster than we expected with the ultimate, the ultimate question of marriage for the whole country.
Any questions? Well, I think this is a good time to thank Jeff and thank everybody for being here. And remember, next week and the week, 2 weeks after, when we come back from spring break, we will be in room 964 on the 9th floor in the new building. Thank you all very much.
Thanks for coming.